I have again read the filings, pleadings, but I want to communicate with Ms. Sims here first. Ms. Sims, do you have a written or oral lease with Mr. Cleveland?
No, I do not.
Hold on, this is already interesting. There is no written or oral lease, but money was exchanged and in court. That creates a gray area because payment can still establish tenancy rights, so the judge is now trying to figure out what kind of legal relationship actually existed here.
Has Mr. Cleveland ever paid you any rent?
Yes, Mr. Cleveland has.
And when is the last time he paid you any rent?
Last time was March. Give me one moment.
I'm gonna need a pause. I have to drive my work truck to the front of the office.
Well, listen, I'm going to ask that you just hold tight because you're in court, and so I'm going to need you to tell, as you know, as I asked.
It was March.
Hold on. So, Mr. Cleveland, I'm going to ask that you not drive and that you take your time to focus on this hearing so that we can complete it so that you can return to work, okay? So just hold tight. You can get back in the truck. But for us to proceed, I'm going to need you not to drive the truck, okay? All right. So, Ms. Sims, you said that was March what?
March 6th, he paid $400.
Okay. Is that how much he normally pays, or he just gave you $400?
He just gave me $400. My mortgage is $1,942.
I understand. But I did review your complaint. You said that he owed you no money, and you're just looking for, I guess, his possessions to be removed. In that case, did you provide him any other notices that you intended for him to vacate prior to filing this action?
On March 10th, I have a text message from Mr. Cleveland. I was letting him know that I want.
Now things escalate quickly. Police involvement and a TPO enters the picture, and this changes everything because a protection order is not just about housing. It brings in safety concerns which can override normal eviction timelines, so the stakes just got a lot higher.
Him to leave. He said he would leave. I offered 60 days. He said, no, I'll leave that day. He didn't. On or about March 20th, the police was called to prevent any violence, to have him removed, and weren't able to have him removed because of course he's lived here. So I filed a TPO as well as the eviction to get him.
And did your TPO get granted?
It has been granted. They haven't been able to serve Mr. Cleveland.
Okay. You have not been able to. Did you submit a copy of that TPO to the court?
I sent all my evidence to the court.
Clerk Kelly.
Videos, TPO.
Okay, can you submit that to me? I don't see any of that evidence in the file.
Yes, sir.
All right. So you're saying you have a TPO, and that is essentially what would alleviate some of the normal notice issues, because I will say, without a 60-day notice and him being essentially.
Notice what is missing here: no consistent rent, no formal agreement, and no clear demands, and that weakens the landlord position because courts rely heavily on patterns and documentation. Without that, the case starts to lose structure.
Tenant or resident of yours, particularly with him paying rent, he would have either needed to have a notice of failure to pay rent or a 60-day notice. So just so I can make sure I have all the evidence here, you haven't sent him a 60-day notice because you said, hey, he's going to vacate, and he said he didn't need it. And then in addition to, he's been paying you money, but not necessarily the consistent amounts.
Right.
Okay. And have you demanded any consistent amount ever?
No.
Okay. All right.
I handle it myself.
And I'm going to look for that TPO paperwork, but to your knowledge, when was that TPO granted?
That was granted on April 1st, excuse me.
Okay. And when you said he has not been served with that TPO, does he not currently reside at the property?
He has not resided here since on or about March 20th. And they don't have another address for him, so all that they can do was mail it to this address, to the address that we shared.
Okay.
And I would also like to state that on April 6th, Mr. Cleveland showed up to the property unannounced to grab things out of the property. I wasn't able to let the police know because he was just grabbing stuff, and at that point he could have gotten all of his things, but he refuses to. He would rather go around and around with this.
Okay. All right. Well, I'm still looking for the copy of the TPO order, which would be necessary for me to really make a full consideration. But let me speak to Mr. Cleveland. I'll give you a chance, Ms. Sims, to go ahead and put yourself on mute. Mr. Cleveland, I'm just going to ask you a couple of questions. One, Mr. Cleveland, just to make sure, do you have a written or oral lease with Ms. Sims?
No, sir, not to my knowledge.
Okay. And have you ever paid her any rent?
Yes, sir.
And when's the last time you gave her any money?
Hold on, I can look. Hold up 1 second.
Sure. Yes, sir.
Let me look at my bank account 1 second.
And Clerk Kelly, were you able to find any of that evidence that Ms. Sims is referring to?
No, sir. I was just about to send Ms. Sims a message with my email address.
This is a major emotional turning point. The tenant claims fear and pressure, saying he wakes up to a camera in his face and feels targeted. Now the courtroom is not just about property anymore. It is about credibility and whose story the judge believes.
If she can forward that to my email.
That'd be great.
Okay, thank you.
All right, I'm sorry about that, Mr. Cleveland. What did you say?
It was March 6th.
Okay, was that for that $400 that Ms. Sims had mentioned earlier?
Yes, sir.
Okay, and did she ever demand that you pay a consistent amount of $400 every month, or just you were
the $400? Okay,
$400. And have you ever received any type of 60-day notice from Ms. Cleveland instructing that she wanted you to vacate?
Yes, no, sir.
Have you vacated the property?
Yeah, because I haven't been. I mean, I feel like she's trying to get me locked up just to even lay there to go to work. Every day I wake up with a phone camera in my face.
I understand. Are you aware that there's a TPO?
I'm not aware of any of this stuff. I mean, only thing that I know about is the eviction, because a neighbor called me and told me that some paperwork was on the door, but I haven't been there since all this happened.
Okay. See the TPO. Is there anything else that you'd like to let me know? And I understand, Mr. Cleveland.
Here comes the legal twist. A TPO and an eviction are two completely different legal tracks. One is criminal or protective and the other is civil and procedural, and even if they lead to the same outcome, the court cannot skip steps on the eviction side. The distinction is critical.
With you saying that you haven't been served with the TPO, but obviously you're saying that you've left because of your concern about being arrested.
Yes, sir.
But then at the same time, there's some other issues. Any other letters or communication that you received from Ms. Sims?
No, I have. I want to know how to go about filing for items that I'm missing.
Well, honestly, I don't want to get too into it yet. I'm not until I really see the TPO. That'll have some impact about what's going on. But that'll, in fact, regardless of what I do, the TPO will have its own impact, right?
Yes, sir.
This case, just so Ms. Sims as well as is aware, is governed by certain statutes regarding landlord-tenant law. Now, the TPO is something different, and it's criminal. And if there is a essential order for you a protection order, then you essentially would not be around her, and by virtue of that, would basically be evicted because of that condition. But that necessarily wouldn't mean that I would grant a writ of possession.
Let me
because hold on, Mr. Cleveland.
Okay, go ahead.
Hold on, Mr. Cleveland. And so grant a writ of possession because if the certain elements have not been met, that may not be granted, but the effect may be the same because there's a TPO that effectively would make you have to stay away from Ms. Sims. Okay, so let me look at that, and then I can give you a real direction about what we're going to do. Because Ms. Sims, it appears, just so I want to make sure I understand all the evidence. You haven't sent him a 60-day letter. He has left, but he has not. I understand, service with him vacating, but not being there and coming back. I understand there's a tack and mail service situation. He did answer. So we've got that going. However, he still would need to have at least been provided, some type of notice for me to be able to grant you a writ. Now, if you've got a TPO, that doesn't matter, right? And then a lot of times with TPOs, there may be an ability for him to have a trip with an officer to get the remaining of his belongings. That's often associated. But again, until I see that, I can't really give you direction. So I'm still waiting for you to send that information to my clerk.
I sent it to her.
Okay, and then once I get that, I'll have that forwarded over to me. So I'm going to ask Mr. Cleveland and Ms. Sims just to hold 1 second while I take a look and review that evidence. You both can go on mute, and then I'll follow back up with you, Mr. Cleveland. Hold tight. All right, let me just give you a little bit of information, and I don't want to overstep my bounds because they're two separate cases. And Mr. Cleveland, if you can, I can't communicate with you while you're driving that truck.
I'm not driving this truck.
Oh, okay, good. Okay, well, thank you. Appreciate it. Well, what I was able to review was an actual TPO order. There apparently is a hearing that is upcoming, but it does give restrictions and stayaways regarding Ms. Sims and the subject property. So that's going to be in place, and it does give you a trip with an officer to get your remaining possessions. And so I'm going to hold on.
And there it is, the final decision. The judge denies the writ not because the situation is unclear but because the legal process was not followed correctly. This is a powerful reminder that in court procedure is everything. Even when the outcome seems obvious, you still have to follow every required step.
On that. Now, Ms. Sims, despite all of that, you still are required to do the necessary notices for Mr. Cleveland to get a writ of possession. The TPO would effectively remove him and give him an opportunity to get his possessions. But as far as the writ and the marshals and all of that, that's totally separate. As I said, it may have a similar effect, but it is not the same. And it appears, based upon the evidence, you have not given him the notices under the impression that he is already vacated and you're just trying to cover your bounds or yourself, or you're making sure you do everything. But it doesn't seem like you've done that. But you do have a TPO. So I can't give you a writ because you haven't done the things you're supposed to on that side, but you got a TPO, so he can't come back and he cannot get an opportunity to get the remainder of his possession. So, and he's not there now as well. So I just wanted to kind of give a sense and make sure I understood the whole position. So just so you understand, I'm going to deny the writ because you don't have the notices there for me to give it. You still got to do all those things. You can't avoid that just because you have a TPO. But because you have the TPO, he is prevented from returning to the property, and he does, according to the order, have an ability with an officer to go get those remaining possessions. So that effectively has a very similar effect. Ms. Sims, last couple questions.
Yes. So, and that's totally understandable. And that's what I've been trying to do with Mr. Cleveland. You're more than welcome to get your things. I just want an officer here when you do it.
Well, that, and again, I've read the order. I don't want to, again, overstep my bounds. I know he said he hasn't been served and anywhere. I'm not trying to do all of that. But I do know that there's another hearing coming up. And again, without him being served, he may not know all of his rights. And so therefore, that might be part of the frustration. But again, as I will tell Mr. Cleveland, there is a TPO. You may want to inquire about that so that you don't make any unnecessary movements that end up putting you in a position to get arrested. But that is there. And you do, Mr. Cleveland, have an ability, according to the order, to go with an officer to get remaining of your possessions. And yes, Mr. Cleveland.
So why would someone file a TPO on you if they want you to get your things?
Again, that's irrelevant to what I'm telling you. I'm just telling you that there's a TPO and that you have an ability to get your thing. So I ain't even Mr. Cleveland, all I'm telling you is what I've been informed of.
Yes, sir.
What her reasoning is really irrelevant. I'm just telling you what it is. And I'm saying in order for you to do that, you might want to contact an officer or inquire about the TPO so that you can make the best decision for you. But I can't make those decisions for you. But I am going to dismiss the case, Ms. Sims. You do have a TPO, Mr. Cleveland, and the order will be dismissed again, but the TPO is still in play. So that'll be the order. I will let you folks go. I will file the order of dismissal, and hopefully you guys have this all resolved. But you are free to go this morning, okay?
All right, thank you.
Yes. Ajita, I want to make sure, is there a written or oral agreement with Ms. Muhammad and Wiseman Research Group?
Yes.
Okay.
Yes, sir.
All right. Has that lease expired or is it still in play?
It's expired. She was on month to month.
And when did it expire?
2 years ago.
Okay.
She's been on a month to month.
Does she still reside there?
No, she's moved.
When did she vacate?
She vacated the 20th
Of March?
of March. Yes, sir.
Okay.
Sir, that is incorrect.
Miss Williams, please. I see you guys are excited, but as if you haven't watched, I'm gonna give everybody an opportunity to speak. Please don't speak while other people are speaking. It just makes it's unnecessary. All right, so Miss Wajid, so she's vacated. I see she vacated on the same day that you filed this action.
Yes, sir.
And you're not looking for any money.
Yes.
And
Right. Not for rent. No, sir.
And I don't see any specifically pled damages. What damages are you alleging?
I did submit to the daughters the damages from her moving out. I did give her credit for the time she wasn't there, but this started in January when I became aware that Miss Muhammad was breaking a lot of the rules of our agreement, being that she had too much stuff in the room. She was just hoarding. She was not living there cleanly or safe.
And let me stop you because I don't want to go too far in the facts that aren't really relevant right now.
Right. Okay.
If she's already vacated,
yes,
and you didn't have any money, and at the time that you filed this, you were going to ultimately have to do some type of security deposit or some type of move out. Since that has kind of already occurred, it really seems moot at this juncture. You haven't asked for any money.
Yes, I have asked for money, but
forgive me. What I mean is you haven't specially pled anything. You've asked for court cost and damages, but your damages aren't specifically pled. And then furthermore, the damages that you've just alleged are talking about her move out expenses, and that's separate from costs associated while she was actually a tenant. And so that's something that you might need to pursue separately, particularly if she's already vacated or she vacated on the day that you filed this action.
Yes.
That would be problematic as well. There is no real recourse order I can give you. I'm not going to give you an order for any money because you haven't specifically pled anything. I'm not going to give you an order for a writ because she doesn't live there. And are any of her possessions still there?
By the agreement, I had them move because they left, and I agreed that I would have her things moved from her residence at my place to her new residence. I moved all her things there. I paid for someone to move all her things, set up her bed, put TVs on the wall, take her things there. But the agreement was that they were going to pay for that. Now I also, because she had so many things in the room and was just unable to take care of herself anymore, there were a lot of damages beyond normal wear and tear. Now, the fact that
so Ms. Wajid, again, I've already told you that that's independent of this.
I got you. Okay.
Because she's already vacated, you haven't specifically pled any of those damages.
Okay.
And many of those were after she had vacated, which would be applicable for some type of independent action, but not for the
Okay. Maybe it's a small claim. I'll do small claims. Yes. Absolutely. Yes, sir.
And so that's what we'll be doing. And I'll just let the daughters know. You guys really aren't a party to the action and really don't have any to speak on her behalf. But I did want to give you an opportunity to be able to at least hear what we adjust since she's here. Okay. But that's going to be the order, which will be just dismissed because she's not in possession and there is no amount that was demanded. So that'll be the order recorded dismissed. And
sir, I did put on there that I wanted damages in court costs and fees.
But I think the case, based upon what you've already told me, that you filed on the day that she moved.
I didn't. It wasn't even.
It's okay. The case.
Yeah, I filed that morning, and she moved that evening.
It's okay.
I understand. Okay.
This is dismissed, and you guys are free to go.
Thank you, sir.
Thank you.
Thank you, Mr. Williams. You guys are both free to go.
Thank you.
Thank you, sir.
Yes.
This second case is a perfect example of timing going wrong because the tenant already moved out and no clear damages were properly claimed, which leaves the court with nothing solid to act on, and it shows how even a valid complaint can fall apart if it is not filed with the right details at the right time.